and thank you for attending in person. We're looking forward to go back to larger audiences as we used to have before the pandemic. Now, secondly, I'd like to thank Jonathan Webb, the host, and his marvelous firm, the new firm with very positive energy. And actually, I noted they have 10 ladies, a small firm has 10 ladies as solicitors. That's good for the pledge. Well done. And this is an inauguration of the firm as a venue, because we have our most important event with such an esteemed panel. Third, I would like to draw your attention. Well, of course, you know the bill is still a bill, and you can make any comments you like, make suggestions. And if you notice any non-apparent weaknesses of the bill, you are welcome to discuss them tonight. I think it's the last chance, or no chance at all, Nathan?
It's a democratic process.
Okay, good. Well, the followers of LSLC know that the remit of LSLC is to promote reform, to challenge the status quo, and debate hot issues. And this is one of the hot issues we are debating. In my view, the Law Commission has carried out thorough research and analysis, and they have answered almost all the suggestions made through the consultation stages. I think that the bill is a bit cautious, but is balanced in terms of maintaining the delicate relationship between the courts and the arbitration. And in this connection, I'd like to remind you, Lord Campbell's, the old Lord Campbell, 1800, okay, observation that English judges traditionally had a jealousy towards arbitration. And this, of course, is disputed by a renowned academic, Professor Stavros Rekoulakis of Queen Mary, who has written an erudite article recently and challenges the arguments or the assumptions that the courts are hostile to arbitration based on all decisions of the 18th and 19th centuries. Well, and I put this question to you, considering that there's a steady stream of judges to arbitration nowadays in recent years. Could we say that the judges are actually coming to arbitration out of a great admiration for London arbitration? Or is it the jealousy still persists today? Jonathan, over to you. Not to answer the question, but...
Thank you very much, Aleka. It was, of course, my professor when I first came to London in 1993, studying at UCL. This Fugit. So we are delighted to be hosting the LSLC and this very illustrious panel to explore a topic, as Aleka has already said, which resonates for all of us in the commercial and shipping space and the users of dispute resolution services in London. On behalf of our young firm and my partners here in London, as well as across the pond in our New York and other American offices, as well, and also not to forget our partners in Vienna, it is my great pleasure to welcome everyone, both in person and remote, to this event this evening in the heart of bigger London. It's fantastic being here between Gray's Inn and Lincoln's Inn, the court's just down the road. Quick announcement before my main function, which is introducing Sir Jamie and handing over to him. We have drinks. This is the sort of additional floor to our offices. Our main floor is downstairs, and Afterwards, you're all very welcome to join us on our roof terrace for drinks and some hot food that's been prepared for us by Davy's Wine Bar. They'll be bringing it up. To get down there, you'll need to go down the stairs there, or there's a fire escape which will open up. But either way, going down, just be careful on the way down. Right. So without further ado, it's my job to introduce Sir Jeremy, which is my great pleasure to do. We agreed in the brief trial run discussion that all introductions will be kept very brief. And I know Sir Jeremy is planning to make brief introductions of his illustrious panel because they're all so well known. Of course, because he's also so well known, I'm going to be brief, and he'd be very cross if I wasn't. So Jeremy has been he took silk in 1990 and has practiced in all the areas I think that resonate with people in this room: shipping, marine insurance, non-marine insurance, reinsurance, professional negligence, banking, international sale of goods, and energy. He's also, since retiring from the bench, built a substantial arbitration practice. Most significantly, as I think pretty much everyone in this room will be aware, he was the judge in charge of the commercial court from 2012 to 2014. And I will conclude, I found a lovely passage, which I risk of embarrassing Sir Jeremy, and with the prospect of Section 69 and appeal coming up later, you'll see, I love this passage. He was, during his time on the bench, so the statistics show, the commercial judge whose decisions were least likely to be overturned in the Court of Appeal, and has been, on more than one of those few occasions, upheld by the Supreme Court. He was renowned for the speed at which he produced his judgments, and his informal and down-to-earth approach, and the firm but fair and polite efficiency with which he conducted his trials. So, Jeremy, over to you.
Thank you very much. I'm going to stay seated, as indeed will, I think, each of the speakers. Let me just tell you about the structure of the evening so you know what's going to happen. Each of the speakers is going to address one topic. We're going to start with Sir Richard Akins. He's going to talk about the law governing arbitration. And when he's talked about that for a bit, I'm going to invite Nathan Tamling from the Law Commission just to have a quick sentence or two to explain why the Law Commission got to where they got to. And then we're going to throw it out for any questions, any discussion from the floor here, and those who are online can be sending things in, and Jonathan will have those ready to hand so that I can introduce those as they come up. So Richard first on Section 1 and the amended Section 6A. Then Mr. Justice Henshaw is going to talk about Section 67 and the challenges to jurisdiction of arbitrators, again followed by Nathan and Q&A discussion. Hopkins, KC, next on Section 44 and the court's powers in aid of arbitration, peremptory orders perhaps coming in for a quick mention. And again, same format, Nathan to add something and then open to the floor. And then Nathan's going to talk a little bit about discrimination. This is assuming we've got time for all this, of course, so we'll see how we go. Again, an opportunity to talk. And then finally, if we've got time, we may look briefly at the Section 69 test and how that's operating and whether views are that it needs to be taken with a more relaxed outlook or whether the commercial court has got it about right for the present moment. It may be that people will want to also raise the latest problem that's come about as a result of Julian Flow's decision in the Minsk case, which has thrown a spanner in the work of all Russian arbitrations and certainly presents a problem for Sir Richard and myself in one we would have been sitting in today. But there we are. With that, I hope that's fairly clear, and I hope you'll be thinking about matters as they go forward and the sort of issues you might want to raise at the end of each individual person's topic. So, Richard, please.
Thank you very much, Jeremy. I'm assuming I meant to talk from here rather than up there.
Entirely up to you, but yes.
I'd much rather do it from here. I want to talk about the proposed Section 6A of the Arbitration Act, which is in Clause 1 of the draft bill. And it's about changing the law on the applicable law of an arbitration agreement. Now, why, you may ask, is that important issue? Well, the applicable law governs the validity, the scope, and the interpretation of an arbitral agreement. And there are at least 7 situations in English arbitration/court proceedings when that may be an important issue and determine the validity, scope, or interpretation of the agreement, which can then lead on to other things. An application for a stay of court proceedings under Section 9, an application for the appointment of an arbitrator by the court under Section 18, a case where the arbitral tribunal has ruled on its own jurisdiction under Section 30 or 31, where the court considers a preliminary issue on arbitrator's jurisdiction, Section 32, if there's a challenge to an award on jurisdictional grounds, Section 66, 67, and 72, and then finally, when there's a challenge to enforce the award under the New York Convention under Part 2 of the Act, Sections 100 to 103. And it can also arise, as it were, as a stage, or perhaps the first stage, towards the grant of an anti-suit injunction, where somebody is trying to pursue proceedings in court in another jurisdiction, as opposed to going to arbitration as they should do. And that, you'll recall, was precisely what had happened in the Emker and Chubb case, which gave rise to the Court of Appeal and then the Supreme Court judgment, and gave rise to what I'm afraid I'm going to say bluntly is the present mess of the law. That was followed by the Kabadji case, which was an enforcement case where there was an attempt to enforce in this country and an attempt to enforce in France, and the English court and the French court came to directly opposite views on what the applicable law of the agreement was, and therefore whether it was valid or not. So those are all situations which might give rise to issues, and therefore, in the view of many, including myself, the need to have absolute clarity in the law is paramount. And you remember that Andrew Popplewell, Lord Justice Popplewell, in the Court of Appeal, said that the aim should be to impose some order and clarity in this area of the law. Well, that their lordships certainly did not do, and it reminded me of Laurel and Hardy, what a right mess you got us into. Hence, the appeal to the Law Commission, when it started doing its work on possible reforms, to consider a simple statutory default rule if the parties had not expressly chosen an applicable law for the arbitration agreement, something which they had already done in Scotland under the 2010 Act, and something which had been part of French law for ages, literally ages. So, Clause 1 does exactly that, and no complaints about Subclause 1, that's very clear, and Subclause 2 also perfectly clear. So the problem is in relation to Subclause 3 of the bill. This section does not apply in relation to an arbitration agreement that was entered into before the day on which Section 1 of the Arbitration Act 2022 comes into force. Now, the effect of that, as is immediately obvious to anyone, is that there will be tens, if not hundreds of thousands of existing arbitration agreements which will be unaffected by it. And this could go on for years. We all know, as shipping lawyers, of the long-term time charters that have arbitration clauses, usually Arbitration London. What about all those construction contracts, which could be long-term? Energy supply contracts? The list can go on and on. So that if this is the wording that comes into force, then it will mean that effectively there will be a two-tier system. That which exists and all the mess it produces for current arbitration agreements, and that which will be effective sometime in the future but only fully effective after a very long period of time. And there are two cases, recent cases, which involved anti-suit injunctions, where this issue of what is the applicable law and how it affects whether or not an anti-suit injunction will be granted came up yet again. One went to the Court of Appeal, one was at first instance. Both involved English law contracts and ICC Paris arbitration. And they are SQD and QYP, very helpful name, before Mr. Justice Robert Bright, and then the Court of Appeal, and then G against R in front of Sir Nigel Tier. And they both found that it was English law, but they said no anti-suit injunction because of this connection with Paris, although that was overturned in the first of those two cases. So, what is the answer to this? And the answer that's been proposed by a number of those who've given commentary for the Law Commission's benefit as we've gone along, including a group from my chamber's court, Combar, the commercial judges, and I think others as well, is that there should be a transitional provision along the lines of that in Section 84 of the Arbitration Act itself. And this is not something that's new. The provision in the Arbitration Act is that the provisions of this Act do not apply to arbitral proceedings commenced before the date on which this Act comes into force. They apply to arbitral proceedings commenced on or after the date under an arbitration agreement whenever made, an existing arbitration agreement. Now that we think will work perfectly well. It's tested by a previous use. It's the form of words that was used in the 1889 Act and in the 1934 Act. The 1950 Act was, of course, only a consolidating act and therefore didn't need it. Now, the argument against such a simple and we think effective rule to bring about this necessary change is, as quoted by the Law Commission, that parties might have arranged their affairs on the basis of ENCA. Well, how they managed to do that is really pretty uncertain to me, but it's very unconvincing as an argument, I would say. ENCA's very recent. ENCA doesn't actually clarify the law, and before ENCA, as Lord Justice Popplewell was at pains to make clear, the law had been very murky indeed. The other argument that's been produced is that, well, this would make it retrospective. Well, you could say that exactly the same goes for all the changes that were made by the 1889 Act, the 1934 Act, and the 1996 Act. None, so far as I'm aware, have produced any problems or difficulties by arbitrators or the courts. There is previous form on this issue of whether something is retrospective or not. Those of you who are old enough will remember that Section 13A of the 1950 Act was introduced to give arbitrators a power to strike out arbitrations which had not been pursued efficiently. And the question arose in a case called the Bucra on whether or not that applied to arbitrations which had started before the Act came into force. No, it didn't, said the Court of First Instance. No, it didn't, said the Court of Appeal unanimously. Oh, yes, it did, said the House of Lords by 5-1. I was counsel for the side arguing for it being enforced for existing arbitrations, so I was pleased to win in the House of Lords. And Lord Mustill, who gave the leading judgment and who had also piloted that section through the Lords, said, well, retrospective is a relative word, and what the test is really that needs applying is it unfair to apply this to existing arbitration agreements? And I would say very loudly and clearly, no, it would not be unfair at all. because it would make matters clear and easy. So I join in with all those who would like to see subsection 3 or subclause 3 changed so that of proposed section 6A, so that it has a transitional provision along the lines of the existing section 84 of the 1996 Act. And that's my pitch for this evening.
Thank you very much, Richard. When I asked Richard what he wanted to talk about, he did explain that this was his hobby horse, in case you haven't got the message already. I'm going to ask Nathan for his response to that in the light of what the Law Commission has done and where we may be going in the future.
Yeah, so two very quick things to say in response. The first one is that the submission on this matter from Combar suggests that we don't simply repeat Section 84 of the 96 Act verbatim, taking the same spirit, but that the Arbitration Bill should apply to new arbitration proceedings, but also new legal proceedings, because sometimes things can be afoot, yet the arbitrators haven't yet been appointed. So it's covering both of those angles. I don't think that steals any thunder from your point of principle. We're just so we're clear about that representation. And then the other thing is to get to get legislation to be okayed if it's going to have retrospective effect. There are a couple of steps that need to go through. So it's not quite as simple as persuading the Law Commission. Actually, the Law Commission is now done. We've published our final report, so the Law Commission has no further involvement in this project. It's now with the Ministry of Justice, who are the sponsoring department. If they were minded to heed the submissions that are being made, there are two further steps that need to go through. One is to get law officers' consent, so that's the consent from the Attorney General. So submissions can be made to them, but that is a decision for them to make. That's out of our hands, that's out of the hands of the Ministry of Justice. And then once law officers' consent has, assuming it's granted, it's then still a political decision for the relevant sponsoring ministers to decide whether they want to accept that advice and push on anyway. Though, of course, they will have an eye on, assuming this bill gets a legislative slot in the next legislative session, and we won't know until the King's Speech, but assuming it does, it will be, again, the Law Commission assumes that it's amenable to the special procedure. That means it'll start in the House of Lords. There are plenty of people in the House of Lords with a particular interest in arbitration who might be making similar submissions about retrospective effect. And a minister will obviously have an eye on making sure the passage of a bill is as smooth as it can be and trying to address problems prior to introduction rather than on the hoof after introduction. I'm not sure I can say much more than that, other than it's sitting with them.
Who should they lobby if they want to lobby? Well, you talked about the law officers, but who would you make representations to?
I would say that there's no point in lobbying just yet, because we don't know if we'll get a legislative slot until the King's Speech. About 2/3 of legislative bids are unsuccessful, because there just isn't that time. So we'll just have to wait and see. The Law Commission thinks it'll be special procedure. The Law Commission has its own special procedure. It can invoke once per legislative session for a bill that is not politically controversial. The Law Commission thinks this fits the bill. It doesn't mean everybody agrees with everything we said, but it's not party political controversial. It's a technical amendment. The good thing about a special procedure bill is it is supplementary to usual parliamentary time rather than competitive with it, so it increases the chances of doing it. But we have to wait until the 7th of November. Once that is then through, once we've got a slot, once we've heard from law officers, the person to talk to is the sponsoring minister. In the House of Lords, that would be Lord Bellamy. Sorry, Lord Bellamy.
Thank you very much indeed.
But also, I suppose, one should bend the ear of, as you say, those who are in the Lords who've got an interest in arbitration, of which there are a number, like John Thomas and Jonathan Nance and Nicholas Phillips, Lenny Hoffman, all of whom can shout loudly and eloquently about what's a good idea, and I think they would all be on side with this.
They've put their name to these submissions already, and
Right.
that is known already within government.
Thank you very much. Now, if there's anybody out there who wants to challenge Richard and suggest that what he's saying is simply not right at all, now is your opportunity. Yes, someone over there bravely going to do so.
Arbitrator, I don't really seek to challenge. I think Great Court's written and oral advocacy over the last few months has clearly won the day. But in this forum, I think it is appropriate to point out that the LMAA, the London Maritime Arbitrators Association, has a default rule for the arbitration agreement. The LTIA, the London Court of International Arbitration, has a default rule which is different in favour of the seat rather than English law. Both Enker and Chubb and Kabachi, and indeed the recent anti-suit injunction cases, all arose from cases under the ICC rules. The ICC rules have a lacuna, and I'm sure that in the long term it will be seen as a good thing that the Law Commission and the legislature come out in aid of the ICC. But there are those of us, we are in the minority, who don't think Enker and Chubb is a mess. We think it's a nuanced judgment which supports the different scenarios that these uses anti-suit injunctions, for example, is going on. But it was good law, and it's probably time to mourn its death. And clearly, if some lobbying is done with the Attorney General, then its death will be quick. Thank you.
Thank you very much. Any further comments?
Nothing from the, so my colleagues, Alex, on monitoring the machine, nothing. Okay, fine.
Very good. Well, that's very helpful. Thank you very much. I think.
Could I pose a question?
Yes, please do.
The audience. Do I take it from that response, and I understand the position about Enker, I'm entitled to be rude about it because George Leggett was my favourite.
Sure.
But do I take it then that the consensus is that some kind of different transition position, whether it's as Combar suggests or as other commentators, including those from Great Court, have proposed, is something that would meet with general approval? Because I think if that is the case, I would very much like to go away with that as another weapon in the armory. Well, I wasn't going to risk that, just an acclamation would be.
I think there's a pretty general consensus about that, and I'd be right. Will you nod if you think that's about right?
Isn't it also right to say that the Lords Hamblin and Leggett have somewhat repented of Enker?
I think they are repenting at leisure now. Yes.
But
Not
they
decided in haste.
no, but that they said as much to the Law Commission that on policy grounds they felt it ought to be reversed.
That's true. That's very fair.
They do also see the Law Commission proposal as consistent with Enker, because Enker does have that provision in there that says if the law of the seat says the law of the seat applies, then Enker acknowledges that. So that's how they saw our proposal being consistent with their judgment.
Very good. Yes.
Do we also have to make a mandatory section? It's currently drafted into it's a non-mandatory section. We might get ourselves back into the Enker circle of doom through section 4.5 and another choice of law.
Yeah, the division of the Arbitration Act into mandatory and non-mandatory provisions is a little odd. Non-mandatory provisions tend to provide a set of default rules that parties can opt out of, but that doesn't mean that a statute is mandatory. You can't pick and choose. It's the law of the land. And there are certain provisions in the Arbitration Act which aren't classified as either mandatory or non-mandatory, including, for example, Section 4, which has all these consequences. It doesn't say whether it's mandatory or not. 1, 2, 3, 4, 5, 6. They're not categorized as mandatory or not mandatory. They're obviously mandatory because it's a statute. But inserted clause 6A, I don't think we could put in the mandatory bracket in the way that other clauses are categorized that way, because parties can opt out of it by expressly agreeing. What we hope we've done is by saying in inserted clause 6A2, a choice of law to govern the matrix contract isn't good enough. We hope that that signalling, along with our final report, along with the explanatory notes, makes it clear to whoever comes to interpret it in due course quite what we're getting at. There comes a point with legislative drafting that you can only say what you can say, and then you've just got to trust that the courts are going to do the right thing when it gets there. You can't possibly provide for every possible contingency in advance. We think what we're driving at is pretty clear. So we think it will have the effect it does. But if the courts disagree with us, well, that's the system that we have in this country.
Yeah, well, I agree with that entirely.
Yes, Louis, you're
now going to say
going to say something.
No, it does. Louis got an entirely different point there. And it's this: should there be a cross reference to Section 3 of the Act, which is the Act as the section dealing with the choice of seat? I'm envisaging a situation where there is no seat specified in the arbitration agreement. It may then fall to the court to determine the seat, right? And the agreement, the law of the agreement would follow the court's determination. I'm just wondering whether it might be wise to have a cross-reference to Section 3 of the Act. In other words, the seat as chosen by the parties or determined by the court.
But it has to be determined one way or another, doesn't it?
Yes. But it may not be at the time that this is coming up for grabs.
Would that not be covered automatically? I mean, if the Act says the law of the seat in Section 3 tells you what that is, why would that not apply?
Because it does. It tells you that it's the law chosen by the party or determined by the court. I'm just throwing out whether there ought to be a cross-reference to Section 3. I can see it perhaps arising in a situation where, as we all often see, there's no seat specified.
It is certainly a situation that was flagged to us, that what happens if there is no seat specified? What do you do in that situation? And there are some very interesting academic discussions to be had. I think most of them will end up being academic, but because by the time you get it before someone who's got to decide what the law of the arbitration agreement is, whether it's the tribunal or the court, that person will be empowered to decide what the seat is, and therefore will be able to cut through the difficulty. But I take your point about section. I need to think about it, but I can pass that on to my masters.
Thank you very much. I think probably we need to move on to the next topic. So, there are some seats down the front if you are happy to make your way towards the front, if you'd like to do that. It'll be more comfortable. Thank you. Mr. Justice Henshaw is going to talk to us a little bit about challenges to the jurisdiction of arbitrators in Section 67.
Welcome. Perfect timing. Can I begin by congratulating the Law Commission on a sustained and excellent piece of work, and especially for listening as carefully as they have done to all the representations that have been made by consultation respondents, and then for acting on so many of them. It really has been a very positive and constructive exercise. Recapping briefly on challenges to jurisdiction, the Commission's main proposal is to provide in the new Act that rules of court may, so it's permissive, include provision that where a party has taken part in an arbitration and the tribunal has ruled on its jurisdiction, then 3 restrictions apply. And they relate to, first of all, relying on grounds, secondly, adducing evidence that was not before the tribunal, and thirdly, rehearing of evidence that was heard by the tribunal. And I'll come on to those in a minute. The discussion of challenges to jurisdiction did take up quite a lot of the Law Commission's report, I think more than 60 pages of the various documents, and it attracted a lot of responses, and I think it's fair to say created some strong feelings. In spite of that, I do wonder whether it perhaps has assumed disproportionate importance in people's minds compared, for example, to the governing law issue, which I suspect in the end will have a more profound potential impact and a positive one on the effectiveness and attractiveness of arbitration in England and Wales. Just touching briefly on statistics, the Commercial Court report for 2019-2020 recorded that only 19 jurisdiction applications had been issued. There were then 15 the following year and 27 in 2021-22. And obviously those figures are tiny compared to the probably 4,000 or more arbitrations taking place here every year. The number of successful Section 67 applications is even lower, and so there's no question of the courts being jealous of the arbitral process. But perhaps what's equally interesting is the relative rarity, certainly of reported cases, where a Section 67 challenge has involved the court hearing substantial amounts of oral evidence, or indeed necessarily any oral evidence. Quite a few jurisdiction challenges have turned on questions of law. English law, sometimes foreign law, sometimes construction of documents. I've given some examples on the list of cases, which I hope was on your chairs, and those include electric steel castings, which was decided based on the construction of a group of telexes, whether there was a contract in place at all. The Peterson Farms case, which turned on Arkansas law, specifically the law on piercing the corporate veil. Mr. Justice Aiken's decision in the prime trade case, which was decided largely on 2 points of law under the Carriage of Goods by Sea Act. And the judge also made the observation that the court can decide not to permit new evidence to be adduced if that would result in substantial prejudice to the other side, but can't fairly be dealt with in costs, or, if appropriate, an adjournment. And the other example is my decision in the Port de Djibouti case, which was all about contractual construction. Then there's another group of cases where a jurisdiction challenge has carried the potential to lead to vistas of oral evidence, but that's been avoided in a number of different ways. So, for example, in the Callisti, Males J avoided it on the grounds that there hadn't been full disclosure, and therefore it wouldn't be fair to allow the new evidence to which it would have related to be put forward. Mr. Justice Tier in X and Y, dealing with a bribery case, directed that there should be a preliminary issue on the effect of the separability doctrine, because it was certainly well arguable that under either of the candidate laws, the allegations of fact couldn't help the respondent in any event. And then in the province of Balochistan case, which is a more recent one, there was another corruption case that was disposed of on a preliminary issue about loss of the right to object. But having said all that, there will be, of course, a residual category of cases where there is the prospect of rehearing evidence. And so how then will the proposed new rules affect things? The first obvious point is that we won't know until the Rules Committee has decided what, if any, rules to make. And of course, part of the idea of the Commission's proposal is that rules can be adapted as time goes by in the light of experience. But let's assume for a minute that they do begin by making each of the three types of rule the Commission has proposed. The first new rule, restricting new grounds, aligns, as the Commission recognises, with the existing provision in section 73(1)(a), preventing reliance on, quote, any objection, unquote, not raised on a timely basis. Although I realise there is case law on the scope of the concept of any objection, I rather suspect that this change is not likely to amount to a major departure from the position we have at the moment. The second rule about fresh evidence is rather similar to the rule applied in criminal appeals. According to at least some case law, this is the approach taken on jurisdiction challenges in Singapore. It may have the salutary effect of inhibiting parties from deliberately keeping evidence up their sleeves for use in court later. Again, it may have an impact on some cases, but I don't expect that it's going to produce major changes. The third rule, which we see in C there, is about restricting the rehearing of evidence the tribunal has already heard. Some of the respondents to the Commission have made the point that various of the objections to rehearing evidence are debatable, and that's certainly an arguable proposition. But I think the key point is that the Law Commission's proposal leaves it to the court to decide where the interests of justice lie. And so the rule can accommodate different approaches along a spectrum of cases. At one end, there are cases where any oral evidence is fairly peripheral and can easily be taken from the transcript, assuming that is that there is a proper transcript of the evidence. At the other end, for example, may be a case where the whole jurisdiction debate turns on whether an alleged oral contract was made or not. And the issue is what was said. A good example is Mr. Justice Phillips's decision in A against B, which is also on the sheet. That's the 2015 decision. And that was a contract formation case where the oral evidence really mattered. And after a 2-day hearing, the judge made findings on credibility and held that a contract had been formed, so the arbitrator did have jurisdiction. And so in that type of case, one might anticipate that even under the proposed new rule, the court may think it's sufficiently important for it to hear the witnesses itself. And so just to conclude, by trying to answer the question posed in the flyer, I would not expect the new rules to tilt the balance in any significant way, but I think they may embolden the courts when addressing apparently unmeritorious challenges to do so in the most efficient way possible without unfairly limiting parties' rights to challenge jurisdiction.
Thank you. Nathan, do you want to add anything?
It did attract a lot of debate, and there were strongly held views on both sides. That said, there is a strong majority support in favour of reform. The challenge has been trying to find essentially a middle ground between two camps that were polar opposites. And that's what we've attempted to do here. Some people have called it a fudge. I would say it is a pragmatic compromise. Anybody who's had the pleasure of reading the travaux preparatoires that led to the UNCITRAL model law can see the bargaining that went on between the nations and how some choices of language was deliberately open textured to avoid reaching a decision. An interesting thing with section 67, I said there was strongly held views. They're almost all theoretical. Almost everything else that we've had to consider was very pragmatic. What worked best in practice. Whereas this, there was an awful lot of theory about which way we should go. And I'm not sure that any of that theory well, I am sure that none of that theory had a knockout argument. What you need to try and understand is that one party says the tribunal should never have heard it, and the other party says the tribunal should always have heard it. But you only ever know which is right after the event. And in the meantime, you've got to try and take a position that acknowledges either could be right. And that is simply the pragmatic compromise that we've tried to reach. I agree that I think the biggest impact will probably lie elsewhere in the bill. That's probably not a bad thing in this instance. I think the evidence that we've heard told to us is that this doesn't arise very often, but when it does, it's a massive problem for those few people involved. So maybe the compromise also reflects that sort of statistic, that most people won't notice this change, but perhaps for a few, it could save a lot of headache. But we'll see.
Thoughts from the floor. It's always troubled me that there was the possibility of having this aired first before the arbitrators, and then another go before the courts, and whether that really made sense from the party's perspective. I often wondered, certainly when I was a judge, I used to think, I don't know why the arbitrators bothered with this, why didn't they immediately all agree and have it dealt with by the courts? But I throw that out in the light of what Mr. Justice Henshaw has been saying and what Nathan's been saying. Any comments, any thoughts, any questions?
Can I put in a point, which is made in the course of submission to the Law Commission? Will this create a difference of approach, might be unhelpful, between what you can do under Section 67 and these proposed rules of court, and what happens when you come to enforcement proceedings and there's a challenge on the ground of jurisdiction? I had the Dalla case at first instance, and the challenge there was to jurisdiction on the basis that the government of Pakistan was not a party to the arbitration agreement at all. And I heard two French lawyers, very distinguished, on what the French law principles were on how you decide whether somebody was a party to an arbitration agreement, because the default position was that it was all French law. And of course that hadn't happened at all in the arbitration. There hadn't been any such evidence. But I ploughed on, and the Lords, I think it was the Lords, or was it the Supreme Court, agreed with my ruling. And then, of course, the Cour de Cassation said, "Oh no, that's complete rubbish. Of course they're parties to it."
The Cour d'appel.
So you're quite right. The Cour d'appel, who said, "No, it's complete rubbish." So I wonder, would that be an unfortunate distinction, or not, or doesn't it matter? That's the thing I pose. Do you think? I mean, Nathan, you must have thought about this in the Law Commission and concluded that it wasn't really necessary to worry about that.
There's certainly nothing that we can legislate that's going to change the mind of French courts. They will do their thing. We've got to look out for our thing, and maybe timings could have been better managed in certain cases. So the frameworks are, I don't know. I'm going to be politic and leave it at that point. I think if we're looking at distinctions between Part 1 and Part 3 of the Act, so between domestic challenges, as it were, and challenges under the New York Convention, I think we're entitled to say the New York Convention, we can't play with that. We just have to leave it as it is because it's an international convention. And it is deliberately broad because it has to deal with awards emanating from such a wide variety of circumstances and different local practices. But what we can do in our own country, we can be much more rigorous. And if that has the effect of selling London as a better place to seek your arbitration in the first place, because we've got a much clearer code of what's going to happen, that's not a bad thing in itself. So we can be more rigorous for ourselves and have to be more flexible when dealing with foreign awards.
Can I come back on that, Nathan? The New York Convention has an express provision that you are not allowed to be more onerous in the treatment of an incoming award than you are for a domestic. You can be precisely as onerous. So I think the solution, which I in fact support, is to throw this into the hands of the Rules Committee to develop rules. There isn't, I think, a reason why the same Rules Committee couldn't have a similar rule for a Section 103 challenge from jurisdiction. It's a matter of procedure rather than substantive law. You're not touching Section 103 as such, but you are making it slightly more onerous. So if another solicitor agent has to face a Dallas situation, they'll be able to point to a rule of court that says, sorry, same thing for Section 103 challenges as there are for 67. Again, I've thrown it out there as a something of thought. Obviously, when you were thinking about this, there was a massive argument that there was a discrepancy between the treatment of 67 and 103. But if the answer to 67 is to leave it to the court, that seems to be an argument in principle why that couldn't be made for 103, given the terms of the New York Convention.
I suppose at the minute, there couldn't be any rules of court because there isn't the power to make them in respect of that part. But there'd have to be an amendment to the bill, wouldn't there, to give the Rule Committee the power to make rules of court in relation to Part 3 of the Act.
Yeah, I think that's probably right. I think there's no reason why an approach under Part 1 can't influence an approach under Part 3, and especially in respect of other jurisdictions which have a very respectable tradition towards arbitration. There might be some seats which you might want to review a little bit more closely, but there'll be many seats which, with arbitrators who are very familiar to English courts, whether they're seated in London or Paris or Singapore or wherever it might be. I think what you say too is, I mean, it is true that whatever approach we took in respect to Section 67 is compatible with the language of the New York Convention.
I think in terms of it being more onerous, it can probably be reconciled on the basis that none of this is changing the substantive test that's being applied. And true. Therefore it doesn't infringe.
Nathan said that this discussion in the first place had some very strong views on each side of the fence. Are those reflected in the assembled multitude? Do people have strong views one way or the other?
I was a very big anti-2 bytes.
Yes, but you've changed your mind.
I haven't changed my mind. I think that the rules of court, if well drafted, will cure it. I think the Ladding Marshall test was always something that should get better. So that's a great test. You can't just come with a new set of evidence that you could, with reasonable diligence, have put before the tribunal.
Understood, but that won't necessarily stop people having a second bite at the cherry, will it?
It will cut down the evidential burden that the court faces.
Well, it will certainly make life easier for judges. That's certainly true. That's not actually the object of the exercise.
No, it's less costly for the other party to have to rehash all the evidence again and have all the...
Yes, true. It gets rid of an element of abuse, undoubtedly. Yeah.
My sense, for what it's worth, is that most people are quite happy with the fudge. Last time we had a London Shipping Law Centre session on this topic, views really were divided, and people were getting quite agitated about this. Speaking for myself, I'm actually a pro 2 bytes person, because I think conceptually it's the only fair thing to do. And I see perhaps I might have fallen into Nathan's trap of being too academic, because I do look at it from the perspective, as he says, that one party thinks the arbitrators are the only people empowered to decide the point, and the other party thinks that they have no power whatsoever, and that is difficult. But my feeling is that rules of court are the way to go. As to the impact they will have, I think that Andrew is right, that actually the case where it makes an enormous difference is the fairly rare case, and everyone says, oh, what about the pounder? And the pounder was a horror, but the pounder was a rare case. There are lots of cases where it's very, very different. And A and B, which is the case that Andrew mentioned in which I appeared, was very different. One of the reasons it was very different is that it was a commodities arbitration, and the award had been on paper. There'd been no previous hearing. It had all been done on the documents. And as to how well it had been done on the documents, I leave you to speculate. But those of us who dabble in that particular world, it's very, very different. Often the hearing before the court will be the first hearing there's actually been on the issue. And that perhaps puts a slightly different complexion on it.
Can I just make one point in response to what Jeremy said about why do the arbitrators bother? I think one answer to that is that there are obviously a lot of cases where arbitrators decide on jurisdiction and then they go on to decide on the merits. Sometimes they do it at the same time, and the case may then settle, or it may settle along the way after the jurisdiction decision. And so the jurisdiction decision effectively stands, and it never gets anywhere near the court, but it means that the arbitral process has taken its course and achieved its result, either through an award that isn't challenged or through a subsequent settlement.
I'm sure that's right. Indeed, in many foreign jurisdictions, the jurisdiction issue is never decided until the final decision, so to speak. But I always took the rather doctrinaire view that the simple thing was for the English court to decide on an English-seated arbitration whether or not there was jurisdiction in the tribunal, and the competence thing didn't really have any significance in that context at all. But there we are. That was yes.
There will be a real risk and degree of procedural archaeology, depending on how well or not awards are. Yes, because I can see parties challenging jurisdiction, popping up and saying, "Oh yes, I argued this." If you look at paragraph 5b(2) in my first submission, I did actually refer to this tangentially. It was then ignored, or the likes. And there will be, this may be one for the Rules Committee, the distinction between the extent to which the court is influenced by what has been written in the award as to what was said. It will then be said that in fact the award is challenged on the Section 68 basis as well. And people digging around and saying, well, actually, I did argue this, and here's a an argument, and it's not consistent to account, so I should be able to argue it before. I lost on this, but I should be able to argue it again.
This is one of the problems where you don't have pleadings in the English sense of the word in arbitration. You have endless submissions, and tucked away in one corner of the submissions is something of the kind you mentioned.
Well, material's good or bad is a different meaning.
Just picking up on that, and actually Philip, your point, looping them in together. I'm just curious, that case you referred to, where there hadn't been oral submissions, was the party who objected cajoled into, did they try and force an oral hearing?
No.
Or, okay, because we,
no, it's a commodities case.
Yeah.
It was an international. It wasn't GAFTA. It was an international cotton association, Liverpool Cotton Association, as was, which is an interesting forum, shall we say? And their rules don't permit an oral hearing first time round. But you're right. There's also GAFTA and FOSFA and the Refined Sugar Association and the International Coffee Association. I even once had a Peanut Association case. I'm not joking. So there's a whole murky world of arbitrations out there where they're always done on the documents, at least at first tier, and often on appeal as well.
Okay, so but if in like with LMAA, if it is you can't be forced to documents, if you sort of just let yourself be pushed down that road, I would say that is something that counts against you on a sort of second bite, because we all know
But I think the cases that often end up with wrong decisions are those that haven't been thorough, in my experience anyway. I think it's probably a paper in there somewhere.
Speak to all those commodities associations, but I'm inclined to agree.
While we're on the subject of interesting procedures, I have a slight drafting worry, which maybe completely wrong, about subsection B. What happens if the tribunal refuses to hear the evidence? Suppose, for instance, a rogue LMAA tribunal which says, we're completely disinterested in this point, this is only $100,000, we're going to do it on documents only, despite you coming along this witness. Does that fall under could not with reasonable diligence approved?
Well, that's a matter for the courts to decide, but I guess if you've exercised reasonable diligence to put it before the tribunal and they've said no, so you've made the effort, you've shown your hand to the other side and to the tribunal, so I guess you'd be okay there. But like I said, there's only so much you can do in drafting, and then you have to trust the court. We're in safe hands there, and I'm sure there'll be a sensible interpretation if it ever came to it. It's the court's own, it'll be the court's own rules too, I hasten to add.
Yeah.
Alex, on any?
Nothing virtual coming through.
Okay.
Philip, I think it's you next, please.
It's me. So I'm going to talk about section 44 of the Arbitration Act. Unlike section 67, this is not a set of proposals which excited strong passions or indeed much interest. I was involved in COMBAR's response to the Law Commission's proposals generally, but this was my particular bit. And when we put it out to consultation, I have to say we didn't get very many responses. And I think that's because this section is a bit bitty and it's a bit tricky and it's a little bit difficult to work out what's going on with the proposals. But it is nonetheless important. We all, I'm sure, have experience of section 44 applications. It's one of the key interfaces between the courts and arbitration. And a number of changes were proposed in relation to section 44 in the Commission's first consultation paper. Some of those have made their way through to the draft bill, and some of them haven't. And there are some suggestions that were made by consultees, including COMBAR, which haven't commended themselves to the Commission. So what's being suggested? Well, I'm not going to go through all the changes and the non-changes in detail, or your eyes will glaze over, but I am going to pick up on 4 points. I'm going to say something first about section 44.1, secondly, the retention of section 44.5, thirdly, something about sections 44.3 and 4, which are staying as is and not being amended. That's not quite true. 44.4 is being amended, but not in the way I want to talk about. And then lastly, I'm going to say something about the new emergency arbitrator provisions. Sir Richard has to leave. He assures me, well, he doesn't assure me, but I hope it's nothing to do with what I'm saying, and I'm not going to take it personally.
It's known as a pre-existing engagement.
Absolutely, probably far more interesting. Now, rather than looking at the draft bill, which is a bit, this bit's amended, that bit's amended, it's easier to look at this by reference to how the Act is going to look if the bill is passed in its current form. And you have on the screen and on your handouts sections 44.1 and 2, and you can see that there is a bit in yellow highlight and underlining. So this is my first point. This is the proposed change to section 44.1. What is this for? Well, this is intended to clarify that the court can make orders under section 44 in an appropriate case against a non-party to the arbitration. Why is it here? Well, views were divided as to whether the court could do this anyway. And some people, including, I think it's fair to say, Nathan, thought that they could, and that the court could make an order under any of the subsections, under subsection 2, against a non-party to the arbitration. Now, my view was, and is, that the law was not and is not clear. there's a Court of Appeal decision in another A and B, there are so many A's and B's, which established that orders against third parties can be made under this one, subsection 2A, but not the other subsections. And many of you will know that in a series of cases, particularly Mr. Justice Mayall's decision in Cruz City and Mrs. Justice Cockrell's decision in D-Tech and Morozov, it was held that orders under at least some of the other subsections couldn't be made against third parties. I think actually the argument as to whether what the law actually does or doesn't say at the moment is a bit sterile if an amendment is going to go through. Whatever the law says, this amendment will clarify the position. Is that a good thing? My view is that it is a good thing. I think that in an appropriate case, which is likely to be pretty rare, the court should have the power to make a section 44A order against a third party. Second point, subsections 3 and 4. The crossed out bit is what 4 is at the moment. The bit that follows is what is proposed it be changed to, and that's really about emergency arbitrators, which I'm going to come on to presently. But as to what this is about, these are the gateways for when the court can make an order under section 44. So we've got section 44.3, urgent cases. The court can make an order if it thinks necessary for the purpose of preserving evidence or assets. And then 4, non-urgent cases, only on the application of a party to the arbitral proceedings made with the permission of the tribunal or the agreement in writing of other parties. We then have to look at 44.5, which says, in any case, the court shall act only if or to the extent that the arbitral tribunal, again, ignore the proposed new bit, and any arbitral or other institutional person vested by the parties with power in that regard has no power or is unable for the time being to act effectively. Taking 44.5 first, there was a suggestion in the Law Commission's consultation paper that this provision should just go. There were 2 reasons for that. It was partly that it was said to be redundant, and partly because of a perceived issue relating to emergency arbitrators, which arose out of the decision in Gerald Metals and Timmins. I've only got 7 minutes, so we haven't got time to discuss that now, but if anybody has the appetite to do that, it's something we can go to in discussions. What the Law Commission has decided is that 44.5 should stay. And what they've said is, it is a valuable statement of the principle of limited intervention. And I think that that is right. I did wonder, and Combar suggested, that there might be a case for taking out the words between the commas to deal with the Gerald Metals problem, if problem it be. But I don't myself think they do any harm. There is a case for taking them out, but it's probably okay that they stay. I certainly think that to take out the entire subsection would have been to send the wrong message. But that said, and this is my third point, I do think the Law Commission has missed a little bit of a trick when looking at these sections. Just going back to 44.3 and 4, what I'm about to say might be thought to be completely contrary to what I've just said about 44.5, though I don't myself think so. 44.3 and 4 do limit, as we've just seen, very substantially the cases in which the court can intervene. And 44.3 is, I think, of particular significance. An order can only be made when the court thinks it's necessary for the purpose of preserving evidence or assets, and when it's urgent. Now, that last phrase, the purpose of preserving evidence or assets, has been interpreted very widely by the courts, and in particular since the Court of Appeal's decision in Settlem and Roust, in which it was held that an asset for those purposes could be a contractual right. And what's more, it can even be a disputed contractual right. So you can go and potentially get an order under Section 44 enforcing the right that you say you have under a contract, when the other party says, well, I dispute that. I don't think there's a right there at all. And as Mr. Justice Mayall said in the Zim integrated shipping and European container shipping case, treating those contractual rights, disputed contractual rights, as assets within section 44.3 is arguably stretching that term, if not to breaking point, then at all events very nearly to breaking point. So in other words, what the courts have done is they've dealt with what they see as a problem, which is to say the narrow language of section 44.3, by interpreting it in a way that I would never, of course, say that commercial judges are dishonest. That would be a wrong thing to say, but it's been a bit of a stretch, put it that way. There may also be a problem with the urgency requirement sometimes. For example, is an application urgent when the nature of it demands secrecy as regards the respondent, but it's not urgent in the sense that it's got to be done today? An application for a freezing injunction, for instance. It might not be so urgent that you need it today, tomorrow, next week. But on the other hand, if you tell the respondent about it, you can bet your bottom dollar that those bottom dollars are going to go off somewhere else. So urgency is potentially a problem. We did raise this in the COMBAR response to the consultation. It hasn't got any traction, at least as yet. My view is it would have been worth looking at those subsections. And going back to 44.5, it may actually be that far from being a problem, 44.5 is a solution, because it tells you that the court should only act if the court hasn't got power, if the tribunal hasn't got power, or the tribunal can't act effectively. And maybe that would be a pointer as to when the court should intervene, and maybe you could loosen or remove some of those restrictions in 44.3 and or 4, and you might actually end up in the same place, but without having to live with an interpretation of 44.3 that really does violence to the language. Fourthly and finally, emergency arbitrators. Now, the way in which this point has developed in the reforms is only partly a section 44 issue. You'll all be familiar with emergency arbitrators who are creatures of institutional rules. And a concern that was raised by the Law Commission in response to views in the market was what happens if an emergency arbitrator makes an order and a party doesn't comply with it? Well, the draft bill includes a suite of measures to deal with this problem or perceived problem. The first is a new section 41A, there it is, and that gives an emergency arbitrator a power to make a peremptory order. Peremptory orders, of course, are dealt with in section 42, and section 42 allows the court to order that a party comply with an arbitrator's peremptory order. And it suggested that that be amended so as to include emergency arbitrators, and then breach of the court's order would give rise to contempt sanctions, because that's the point of section 42. And then lastly, what the Law Commission proposes is that section 44 be changed. That's why the crossing out is there, so that an emergency arbitrator can give permission for there to be an application to the court under section 44. So it's all quite complex. I'm not actually very keen on those changes, though I know others think they are great. I'm not keen on them for this reason. It seems to me that an emergency arbitrator is meant to be a temporary creature. They are meant to be replaced by the tribunal once appointed. Where an emergency arbitrator's order isn't complied with, it seems to me that the answer in a non-urgent case should be to go and get an order from the tribunal once constituted. And after all, the tribunal's appointment ought to be being set in train even as the emergency arbitration regime is being constituted. And in an urgent case, well, you can go to court under section 44.3 anyway. That's what it's for. So I'm not sure this is really such a good idea, because I don't think it's necessary. Do the changes do any real harm? Probably not. And some people really like them. So there it is. There's much more one could say about section 44 and emergency arbitrators, and indeed peremptory orders, but I think I've probably said quite enough for now.
The only real teeth, just the same, that can be applied is by going to the court and getting the order on the stretch in relation to freezing assets and the like, which is going to impact on third parties and so on. And that's the ultimate issue, isn't it?
Yeah, that of course is the state of the law at the moment.
Yes,
and
which is why there's a stretch in it.
Exactly, but that stretch wording, it bothers me.
But there's no real answer to that, is there, on this, in the sense that nothing the arbitrators can do, even the peremptory order of an emergency arbitrator is not going to carry the day.
No, correct. Now, I do think the real question is, perhaps should have been, should you be looking at widening 44.3?
44.3. Nathan, should we have widened 44.3?
Some foreign legislation does it differently. So I think, off the top of my head now, Hong Kong just says the court can make any order, regardless of whether an arbitral tribunal can, unless it doesn't think it's appropriate. So it sort of, you can always go to court and then the court just has a discretion there. So there are different ways of doing it. What we've got here is some legacy provisions. And you know, if you were going to rewrite section 44 from scratch, you might have done it differently. But if you do rewrite it from scratch, it interacts with other sections in the statute. One of the things that we found quite early on in our review is that you tweak one part of the statute and something bulges somewhere else. So you've got to be really careful on what you're doing. So ultimately, we decided to keep faith with the structure that is here and just try to work with it. I agree with Philippa that the law wasn't clear on whether it applied to third parties, but I thought it was clear that that was the intention, that section 44, all it was trying to do was simply track in parallel what happens in court proceedings. You do find different pieces of legislation try to do the same thing. Usually it gives it to a Secretary of State to make regulations that if there's a change in that, then they can make a copying change here. This just tried to import it nicely, to just say, whatever happens in court proceedings, the law will evolve there. Let's bring it into arbitration, but only in those section 44.2 scenarios. So that's what I think it was trying to do. So we just tried to sort of nudge it a bit more in that direction. We could have rewritten 3 and 4 and 5, but as I said, once you start doing that, it tends to upset the balance that had already been struck. When it comes to emergency arbitrators, I guess the first question is, should we recognize them at all? Because the Act doesn't, and other foreign legislation does. Other foreign legislation tends to do it just by saying, every time you read tribunal, read emergency arbitrator is included in that. It doesn't work. It doesn't even work in the foreign legislation, because there are some places where it just, for example, then the court can appoint a tribunal, or the timescales just don't work. Each party has 14 days to appoint an emergency. It just doesn't work. So if you're going to acknowledge an emergency arbitrator, you've got to really think, well, what is at least the very minimum that we can do? And what we've tried to do is say, if normal arbitrators have this regime for making orders backed up by court. So we're just going to give emergency arbitrators that same regime. It's tried and tested, everyone kind of knows where they are with that, so we'll just stick with that. So it's not, I mean, I don't think it's anything dramatic there, it's just trying to work within what we've got. Could we have done it differently? Could we have tweaked the layout? I think we could have done, but it just becomes very messy. And I think we tried to go for a path that kept the faith as much as we could without upsetting too much what was already seemed to be working reasonably well.
Just on other jurisdictions' approaches to the section 44.3 issue, my understanding is that Singapore is different again, and they have an equivalent to 44.3, but they don't recognise settlem, at least at its full extent. They've taken a narrower view of what constitutes preserving evidence or assets, with the result that there's a bit of a problem gap there, on one view.
Well, and the language is tricky anyway, because you've got urgency in section 44.3, and emergency arbitrators have a different definition of urgency. Because some emergency arbitrators can be appointed in a process that takes days or weeks, whereas you can go to the court that same afternoon to get a really urgent order if you need it. So it's trying to balance what we've got here with, you know, a particular set of language here that doesn't necessarily match the language of international practice when it comes to emergency arbitration. And the preserving evidence of assets has somehow got to tie in with what's in section 44.2, some of which is to do with evidence and assets and some of which isn't. So the whole thing is a little bit, the words are written there and you've just got to try and do the best of them as you can. And I'm not sure that if we'd chosen different words, we could have solved it, because all words at some point reach their limit, and as practice evolves, we've got to get creative.
It's going to keep us all in business at least.
Okay, well, there we go. I think we've got it pretty much right. I mean, I sit both in Singapore and in Dubai. In Singapore, you have a problem.
Yeah.
In Dubai, they have no section 44.5. So you've got a very wide discretion to use. And do what you like almost. And some might think that's a step too far. Any thoughts? Yes.
Point about emergency arbitrators is emergency arbitrators under the Act, as amended, would be incredibly fact sensitive to the rules under which the emergency arbitrator is appointed. And somebody's going to have a very early canter, because most emergency arbitrators are effectively functors as soon as they've made their emergency order. So the idea of going back to whichever institution and asking the emergency arbitrator to revive their jurisdiction and make the second order that is necessary for a peremptory order will take some of us for a little bit, I'm sure. The other thing that
they need to change the institutional rules, is
but
what you're saying.
It will be sensitive to, it will depend on the institutional rules. Some institutional rules, as you said, are very quick. Others take weeks, but others, as soon as the order is published, the emergency arbitrator is finished, and then you're off to the substantive tribunal, which should be appointed at the same time. And the other thing is that by taking this approach to emergency arbitrators, it does rather fudge the question of whether the order of an emergency arbitrator is simply to be implemented by the court, or is persuasive to the court when exercising its original jurisdiction. And by most jurisdictions that I can think of have taken the latter route. They say a lot of courts have still remained quite protective of their ability to say, thank you very much for your application for an interim order, and we will take into account the emergency arbitrators. We're not simply going to implement it. Whereas in theory, if you pitch up something that complies with the requirement for peremptory orders, and say, look, I simply want to implement this, and you're not going to have any idea, maybe somebody, Jeremy Cook sitting in London, who's given the order as an emergency arbitrator, and it will look like something that the English will of course. It may not be. It may be something that looks very strange. The powers, as I recall, I don't have the remainder of the section in front of me, the powers of an emergency arbitrator, under a peremptory order, are really quite wide. It's not that's enforcement, but the things that the peremptory order can include quite a wide range of remedies. So
they are, and you can, of course, get into an interesting debate as to whether, in fact, the peremptory order that was made by the arbitrator, or on this hypothesis, the emergency arbitrator, is one which he or she had power to make in the first place.
But it's still left to the court to decide in its discretion whether to make a order under section 42.
Absolutely.
Which uses the emergency arbitrator? Will the court keep using different emergency arbitrators for the same case?
It depends on the rules. So an emergency arbitrator is not a creature of the Arbitration Act and not otherwise governed by the Act, but some institutional rules now allow parties to appoint emergency arbitrators in order to bridge the perceived gap, well, the actual gap, the actual gap that you do sometimes get because it takes a while to appoint a tribunal, but you need something done fast. And that came in, I think, only the most recent version of the LCIA and the ICC rules, and no doubt others as well.
It was first introduced in 2007.
Okay, thank you, David. Thank you, David.
So the court won't appoint an emergency arbitrator. It's usually the institution, usually the arbitrator.
And one of the Law Commission's questions for consultation was, should the court administer a scheme of emergency arbitrators effectively? And I was quite amused to see that I think all but one of the responses said, absolutely not. And I'm sure the commercial judges heaved a huge sigh of relief.
Anybody want to add anything on that topic? I know we're nearly at closing time. There's just one other area that I did want to at least have mentioned, and it comes into have we missed an opportunity here? And that's the discrimination point, which I know will interest some people. So I'm going to ask Nathan just to say something about the discrimination issue and why it doesn't feature in the bill.
Discrimination is largely addressed through the Equality Act, 2010. The Equality Act is long, and it is a difficult read, and it is complex. And once we tried to work out whether we could put something into the Arbitration Act, we soon discovered why the Equality Act is long and a difficult read and complex. I've said this elsewhere, it's a bit like whack-a-mole. Every time something popped up and you thought, I'll deal with that, something else crops up unintentionally as a result. So we ended up in the situation where we made what we thought would be a very narrow targeted suggestion in our first consultation paper. Deliberately narrow, because we saw problems at the margin, so deliberately narrow. Some people criticized it for being too narrow, which is why we threw it open a bit more on the second consultation paper. But on that first one, very narrow, somebody came along and said, well, there needs to be an exception. So and it made sense. So in our second one, we said, but obviously we'd have to have this exception. Then somebody else said, but if you have that exception, then you need to have this exception to the exception. And that was the problem that we found ourselves getting into. Another feature of discrimination is that in a straightforward employment law context, it's often just a sort of bilateral relationship. You've got an employee, they apply for a promotion, the employer doesn't give it to them on discriminatory grounds. They know it's discriminatory, that's what allows them to bring the claim in the first place. If you don't have, you might suspect it, if you don't have that evidence, even the Equality Act won't necessarily help you, but it's usually between the employer and the employee, or the would-be employee and the would-be employer, and it's just that bilateral relationship. And you know what you've missed out on, which is that chance of a job, that chance of promotion. So it's very clear, you get a money remedy. When you put it into an arbitration context, it's more difficult because it's multilateral. If you're looking at, for example, that there was discrimination in the appointment of an arbitrator, there is the arbitrator appointed, there was the arbitrators who weren't appointed, who might have been more favorably considered if discrimination wasn't an issue, there's the arbitral institution, and then there are the parties. And all of them might be able to have a say in this. All of them might be able to police that discrimination. And it's not just a simple case of, well, that person was discriminated against, let's give them a remedy and damages. What happens to everything else? What happens to the process? What happens to the award? The award might have been given by an arbitrator who was selected on a discriminatory basis, but that arbitrator themselves is impartial, impeccably fair, delivered an excellent account of the facts and the law. Should that award be challenged? Maybe if you want to tackle discrimination, but maybe not if you want to resolve the dispute. The difficulty is you end up potentially giving the other party who wants to derail the arbitration process an extra way of doing it by invoking cynically discrimination laws. And that doesn't help arbitration because arbitration becomes messier. And it doesn't necessarily help discrimination if it's always being invoked cynically. It was disappointing to us that we couldn't do something on discrimination but there is no point in trying to do something for the right reason, but just making things worse. One of the things where we took some comfort is once we threw it open more widely in the second consultation paper, it really forced people to think about it in detail. One of the difficulties we had in the consultation was if you say to an individual, should we ban discrimination? Oh, yeah, discrimination's a bad thing. Nobody wants to say otherwise. It was really only Combar who felt able, under the guise of anonymity, Combar, to really push back and point out some of the difficulties. And when we threw it open more widely, so actually we're really running with this, we might ban it entirely, but people started thinking what the problems were. And it actually flushed out quite a range of remedies that are available that probably we didn't realize were available at the time. Now, it doesn't solve everything, and it's disappointing that we can't solve everything, but some legislation can't always solve everything. So we're pleased to have had the debate. We're pleased to have uncovered more tools than were previously people were aware of. We're disappointed we couldn't go further, but we think it was right not to go further because we think it would have caused more problems for arbitration than it solves. That's it, other than to commend the arbitral institutions, because, for example, the LCIA and the ICC, when they appoint arbitrators, they tend to achieve something close to parity between men and women. When it comes to people of colour, that's different. I'm not sure because the statistics aren't revealed, but hopefully, if they're able to lead by example, it will attract other people to follow suit. And there are certainly some corners of arbitration where it is important to follow suit, where they are lagging behind, and ultimately that will do them no good.
May I ask a question?
Yes.
If you decide you don't want to appoint an arbitrator, just because in other arbitrations he basically gave the wrong award, is that discrimination?
No, that's fine.
That's his views.
If you think they're poor quality arbitrator, that's the best reason not to appoint them. So it's just, there are just sort of 9 reasons that you can't choose, and it's things like your sex, your sexuality, your gender identity.
But not their ideas or their approach.
Not their mind. You can criticize their mind.
Being rubbish is not a protected characteristic.
I think we're just about done, unless anybody has a burning issue they want to raise. We haven't talked about Section 69, and we haven't talked about mint, but perhaps now is the time to draw stumps formally, and if you want to talk about such matters informally with the panel or amongst yourselves, feel free to do that. Over what I understand will be food and drink that's going to arrive shortly. Absolutely. But thank you very much, everybody, for attending. Thank you.